At this time, this court does call case number 126906, State of Kansas versus Sebastain Capps. Mr. McGowan, you may proceed, and I will take your rebuttal time that you would like to reserve.
Thank you, Your Honor. I'd like 3 minutes if I may.
I'm sorry?
I'd like 3 minutes if I may.
3 minutes is granted, and well, if you could wait for the clock to get to 15, we can start.
12.
Excuse me, 12. Thanks. 12 minus 3 is 15, yeah. All right, Mr. McGowan.
May it please the court, counsel? Andy McGowan for the Kansas Appellate Defender Office on behalf of Sebastain Capps. I'm here to argue today about the catch-all provision in CORA. Kansas has a lot of crimes that require registration. And one of the definitions for offender that would have to register is any person required by court order to register for any offense not otherwise required by CORA. The district court in this case used that provision to order Mr. Capps to register for the offenses that he was committed of: unlawful possession of a weapon by a felon and interference.
So this wasn't a deadly weapon finding that we normally see where defendants are put on notice of a deadly weapon when it's used as a crime? It's not,
Your Honor.
Okay.
In fact, there was no notice at all in this case that the district court was even thinking of this. It wasn't in the pre-sentence report. The state didn't ask for it. This was at the end of sentencing. It was, by the way, I'm ordering you to register.
Well, I kind of got from that the court ordered it because of his prior convictions, not necessarily his current convictions.
I would agree with Your Honor, except that the record also includes that hearing when the district court went through why the district court was ordering him to register the 27 substantial offenses. The district court also had him sign the document saying he knows the registration requirements. And that document included just the two convictions that he was there for.
Okay, but did the court announce, I didn't get it that the court announced that it was considering it under the current offenses from the bench.
Yeah, I would agree with Your Honor. I just know that the record includes both of these reasons. And in fact, it's an example of why I think this gives the court too much discretion. I don't know that the district court was wrong in reading this catch-all provision to allow the use of prior convictions as a basis to order registration. It's vague enough. The statute itself isn't well written. But in terms of the vagueness, I mean, the Supreme Court has characterized this as unfettered discretion.
You know, I just thought of something, and let me just think this out. So he has 26 or how many priors did he have?
He had 27.
27. So from what you're telling me, outside of these two, the judge made this on the basis of his other 20, 24?
27.
The district court.
But on his priors?
Yes, and the
right.
district court referred to these as substantial, even though many of them are.
Okay, and how many numbers were those?
How many
How many were there of that?
27.
Okay, all right. So let me just throw this out. Under CORA, if he is, let's say you lose, hypothetical, let's just do this hypothetical. He loses and he has to register, right? When he registers and when it comes time at sentencing to look at his criminal history, won't there be confusion? Because usually when you have a CORA violation, you exclude the offense that was included, correct?
Oh, you mean to determine criminal history?
Correct. So all 27, wouldn't all 27 be gone then? I mean that's.
I had not considered that.
Yes. So if he goes up in front of the court, he could be a criminal history. I don't know what these two were. They two felonies or what were they?
One felony, one misdemeanor.
Yeah. So now he's a D.
That could well be, Your Honor.
So this judge, in effect, has lowered his criminal history score from a C to a D because he's saying, I'm gonna take all these 27, consider it. Doesn't that show you how inoperative this ruling by the judge was?
Yes. That's just another example, but thank you, Your Honor.
It's all right, it took me to your argument to put that together, thank you.
Well, like I said, the Marinelli court characterized this, went through all of the different variations of why people have to register, and characterized this catch-all provision as giving the court unfettered discretion. And to be clear to this court, what I think that means is we have constitutionality in spades on this side, and the spectrum ends with this kind of provision.
Isn't that, though, permissible since the Kansas Supreme Court has determined that this isn't punitive?
Okay, so here we go to the question of whether it's criminal or civil. And we spend a lot of time, both of us, on whether it is or isn't. I think there are arguments that it's criminal, even though most of the case law, all the case law is against me. But I will submit to this court that even if it's civil, it's still unconstitutional.
Okay.
Vagueness is a challenge that can be raised both civilly and criminally. The only thing about criminal is that you give less leeway to the legislature.
Do you have a good civil case? Because I think I think you might have cited to a criminal one in that.
The Harris case that I'm relying on primarily in the brief is a criminal case, and the state's argued, well, you can't even consider that. What I would submit to this court, though, is that you can consider it as an example of an unconstitutional statute under vagueness in a criminal context. In a civil context, maybe it is, maybe it isn't. But I'm still saying that on the spectrum, unfettered discretion is on the absolute side of it's unconstitutional. And that's partly because there's no standard.
We put together this sentencing grid, the legislature in 1993, to get rid of arbitrary sentencing, right? That was the goal, is right now, the defendant will be able to look at the box and say, okay, this is going to be my sentence. Same with core registration. These offenses will cause you to register 10 years, 15 years, lifetime. But here, another district court judge will look at his criminal history C and say, that's a C. I'm only going to find those who need to register under this section of the statute, if they're criminal A or a triple A, right? All these felonies. Does that lend the fact of the vagueness that the defendant doesn't know? Because you could have one judge find one and the other say, I want to find it under a criminal history A, because this is only a criminal history C.
Absolutely, that's arbitrary enforcement. And the definition of a vague statute, an unconstitutionally vague statute, is basically if it's so standardless, that is to say there's no word or phrase that you can toy with, that it gives officers, prosecutors, or judges the authority to decide what the law is on an ad hoc and subjective basis. So I agree with what you just said.
There must be, though, a conviction. So, I mean, the standard is any conviction can get you here.
So this goes back to the civil criminal distinction that I believe this court's interested in. I believe that the civil gives the legislature some leeway, more than a criminal case, but not absolutely right, because you can raise vagueness challenges to this or to criminal statutes. The state hasn't argued that I couldn't, and I believe I have discretion. I mean, the court has discretion to hear these kinds of arguments on vagueness for Cora. And so the experiment that I did in my head was for Harris. In Harris, we had the same kind of conviction, but the question in Harris was the residual clause for what a weapon was. And that had like firearm, dirk, danger, stiletto as specific examples of what the statute was about. But in the residual clause, it ended with any other dangerous or deadly cutting instrument of like character. Now, the Kansas Supreme Court found that to be unconstitutionally vague, and that is a criminal statute. But what I considered was, well, what if we took an equivalent phrase and tacked it on to Cora rather than the catch-all phrase that's already there? And that, I came up with any offense of like character. So we have Cora with all the different specific offenses that are listed, and we end with a catch-all phrase with any offense of like character. Now that's a standard. I mean, we can argue about whether a unlawful possession under the circumstances is like any of the other convictions that this legislature has set. We can argue about whether that would include priors. There's a standard. You can evaluate the different determinations that the court made below, that parties raised. We don't have a standard here. There's nothing. We can't argue anything, which is another reason that I'd ask this court to rule on this issue. This wasn't raised below, and so this is a prudential decision on this court. And I would submit to you that this record is as good as it's going to get. Even if defense counsel had raised the argument in district court on the spur of the moment, the answer, the judge would ask, what's your basis, counsel? Why are you objecting to me imposing this registration requirement? And I've been in that situation, and I wouldn't be able to come up with an answer even after thinking about it for a long time. My answer would be, Judge, please don't do this. And that's all I would have.
And is it a 10-year requirement here?
It is a requirement of the term of probation, which was 18 months.
And that has not run yet?
It has not. Unless the court has any other questions, I'd like to
So,
answer.
you're saying he only had to register for 18 months?
Yes, sir. Yes, Your Honor.
All right.
Unless the court has any other questions, I'd like to reserve the rest of my time. Thank you.
All right, thank you.
May it please the court and counsel, Assistant District Attorney Matt Maloney for the state. I guess just to start with, because it was addressed in the briefs, would be the standing question. And I know in his reply brief, defense counsel did specify that he was raising this as a facial challenge. But I would note that at argument, just like in the brief, there has been obviously quite a bit of discussion about the facts of his particular case. We're talking about why he was ordered to register. And was it because he had these 27 prior offenses, or was it because of the offense in this case? What type of notice, if any, did he have? So we're very clearly discussing facts to at least some extent in this case. And so that's where I guess in my original brief, I was somewhat confused as to whether this is truly an as-applied or if we're talking about a facial challenge. And to the extent that it is an as-applied challenge, I think that that is precisely the type of situation that this court should seriously consider whether there is standing to raise this for the first time on appeal, because you simply cannot get around the fact that there's a factual component to this argument that was not developed below. I'm not going to belabor or spend too much time addressing that, but that is something that I would like this court to think about in reaching its opinion. Turning to the merits, just starting with some commonly known standards here. This court does presume that statutes are constitutional, resolves all doubts in favor of their validity, and it is the defendant's burden to overcome those. And because this is not a statute that defines a crime, basically the case law says that it will only be, that it cannot be found vague if it uses terms that an ordinary person can understand. So there is more leeway when you're talking about a remedial civil statute as opposed to a crime-defining statute. And this, further, this is a statute that is only triggered after somebody has already been found guilty of a crime. And so there's no protected conduct that's at issue here. He's already been adjudged guilty of these offenses. So it's not a statute that is determining whether he is in fact guilty of a crime.
Can you help me, remind me, I'm curious about the 18 months because that's unique. Is that specific to that portion, or was the district court judge using his discretion when he ordered the defendant to register for 18 months? Where does that fit in the equation in terms of analyzing how this statute actually operates?
I don't know the answer to that specific question as to whether this is by operation of law or if the term was discretionary as well. But I do think that the fact that it's only an 18-month requirement certainly does factor into the analysis of whether this statute should be deemed unconstitutional when you're talking about a, relatively speaking, a much...
I mean, it could have been a decade though, right?
Well, again, I'm not sure of the answer to that. I'm not as familiar with that specific portion of the statute, and I'm sure counsel can correct me or can clarify that. That was not a focus of the briefing, and so I apologize.
It wasn't a trick question. I just thought it was unique.
No, absolutely. Yeah, I certainly appreciate giving me the opportunity to address that. But I do think that the limited nature, this is not something where he is subject to lifetime registration or even a decade, apparently. It's just an 18-month during the term of probation. And I was looking through my notes to see the date of sentencing, and it was in September of 2023. So I'm not quite sure where exactly he is now. I mean, obviously that's 26 months ago. But it does appear that we would, if not already be there, that we would be close. But again, as far as the actual question on the merits, there's the two prongs to the void for vagueness argument. One being that it doesn't give offenders or doesn't give people fair notice. And with respect to that, I would argue that this statute is very clear. The language is very clear in saying that offender includes any person required to register for an offense not otherwise required as provided in the Registration Act. So it very clearly gives everybody notice that any offense can trigger this. Now, as I argued in the brief, obviously the defendant is not happy with how far-reaching that statute is, but the reach of the statute does not mean that it's vague. If anything, that seems to be more akin to an overbreadth challenge, but he's not raised that argument. So the mere fact that he doesn't like the fact that the court has the discretion to do this, that doesn't make it vague. The words themselves are very clear, and anyone is on notice that the district court does have the authority to do this if it sees fit. So then the second prong is the arbitrary enforcement. And your honors are right that our Supreme Court has looked at this and has essentially said it does give the district court unfettered discretion. And I know that that might cause some angst, but again, I think this is where it does matter, the fact that registration, that CORA has been consistently deemed to be a civil remedial act rather than punishment. And so I think, again, that does give more leeway in allowing for those types of statutes to be found constitutional here. And the district court here was clearly aware that the case law tells us, the legislative history tells us, that CORA was enacted for public safety. Essentially, the goal is to protect the public from certain offenders that the district court, whether it's somebody who is convicted of a crime that requires it, or whether it's something like this, where the district court determines that there's a public safety issue. But that's the purpose of the statute. And here, the district court specifically invoked that purpose in explaining why he was going to order him to register. He specifically said that he felt that he was a danger to public safety, and that's when he referenced the fact that he has a lengthy criminal history, 27 entries. As he noted, they were all substantive. This wasn't something where it was he's got 15 driving while suspended. These are substantive crimes. And then the court specifically mentioned that multiple prior convictions were for public nudity. So you have a situation where the statute gives the court the authority to do it. The court specifies the reason why it found that this particular defendant was, in the court's mind, a threat to public safety. He gave its reasons for doing so, and then imposed this burden, this registration requirement on him. So our position is that, again, when you take into account all of these factors, it is a civil statute. It only comes into play after he has already been convicted. The statute itself does not define the crime that triggered the obligation here. And the court very clearly was aware of the public safety purpose of the statute and found that it was advisable in this case. Now, certainly, other judges might have looked at it and decided otherwise, but that in and of itself doesn't mean that
Let me ask you this, when we're talking about the unconstitutionality of it, are we required to find vagueness and arbitrary, or can we find it unconstitutional just because of the arbitrary enforcement?
Right, yes, I think that the case law does say you can be vague for either of those reasons. I don't think it requires that the court find that it's both vague and that it allows for arbitrary enforcement. I would acknowledge that if he can show one of those two things, then this court could rule in his favor.
And with arbitrary enforcement, does that also apply in civil cases?
I believe that it can apply, but I do think that it is a heavier burden on the defendant to overcome the presumption of constitutionality in that situation. And again, when you're looking at the purpose of the statute and the fact that it's only triggered after a conviction and that the district judge clearly understood the purpose for it. And again, I understand that different judges might have viewed things differently. And I know that this is, again, where something is different in this context than the traditional criminal sentencing situation. There we do have the guidelines that give the district court some discretion, obviously within the grid box. The judge can determine low, standard, or high.
Well, Cora has a lot of guidelines too. I mean, it's a little bit interesting that there are all of these very specific times when Cora applies and for specific lengths of time. And then there's just this one. Theoretically, if Cora was intended to be completely discretionary, you would just need this one.
Yeah, that is true, although I guess the way that the statute is written in general shows that it's not completely discretionary in the sense that the legislature is telling judges, hey, people who are convicted of these certain crimes, you don't have the discretion. They have to register just by operation of law if they're convicted of certain offenses.
Well, and for only this time?
With respect to this provision? Or
No, for the other provisions.
Yes, I think the other provisions, I believe that there's a specific time frame, and I could be wrong on that, but that's
There is, like kidnapping is lifetime, and
Right.
rape, murder, lifetime, but
yes.
others are,
So I think when you look at what the legislature's done, it's essentially said for those offenses that are specifically enumerated, they have to register for X amount of time. People convicted of other offenses can be subject to it in the judge's discretion. And again, with the overriding goal being public safety. And I think that makes sense with respect to the fact that the legislature probably understands that there will be certain offenders who, even though their current offense does not fall within one of the specifically enumerated categories, that their history is such that a judge can look at this and determine that, you know what, even though this is not a person who by operation of law has to register, his individual characteristics, whether it be the facts of this particular crime or taking into account the criminal history, that there are circumstances that cause the judge to think that. And again, I think judges do have discretion. I cited in my brief that, as an example, probation. A judge has wide discretion in determining the conditions of probation. And the mere fact that a judge has that discretion does not mean that it's unconstitutional. So
but people who know that they've committed a crime and are asking for probation, they understand there's going to be conditions. This is something that was just added at the end, was it not?
It was, but again, that's where my point, where I would fall back on the fact that the statute does make clear that the judge does have this ability. And I know that the defendant might not obviously be an expert in any particular statute, but But the statute does exist, and it's something that, you know, a
So
defendant.
if Mr. Capps has completed his sentence and his period of registration, is this issue moot?
I would argue that yes, if he has in fact completed it, and I guess, as I was thinking about this, I guess some of it could be the fact that.
But he's putting a facial
Yeah, I think that's totally.
challenge.
True, and I guess the other thing could be that since he was ordered to serve the misdemeanor sentence in jail.
Oh, that was 12 months plus 18 months of probation.
So yeah, so I guess theoretically he could be still within that period, although we'd be bumping against the end of it. But I guess as to Judge Pickering's point, I think, yes, to the extent it's a facial challenge, that maybe changes the analysis a bit. But I still think generally the question for mootness is a little different than standing. And so for mootness, the question would be, is there any relief that this court could grant in this particular case? And so if he has in fact completed his requirement, maybe that wouldn't necessarily mean that he doesn't have standing, but it would mean that any opinion in this case would be moot because it wouldn't afford this defendant any tangible relief.
Be worth knowing.
Pardon me?
That would be worth knowing
Yes, yes, and that.
for this court, which can't find out on its own.
Certainly, yes, and that's something that, yeah, that I can check on to see, because.
Let me ask you this.
Wait, hold on. He would, if he was ordered to register, wouldn't he have to register notwithstanding probation? Wouldn't he have to register right away?
Well, if he's in jail for the misdemeanor would be my,
Usually
I guess-
defendants start registering while they're in jail.
then to the extent that's the case, and again,
If you could, yeah.
yeah, my underlying knowledge of how the particulars of the registration works is not obviously the greatest, but if that's the case, then that would also seem to indicate that just from a math standpoint, that yes, that he would be, already have completed that. And as I said, counsel might know the details of this better than I do, and I certainly wouldn't dispute if he has some specific knowledge with respect to whether his client has finished his requirement.
I did have a question about the arbitrary enforcement part of this. I'm interested in the length, because in the statutory language, where if you commit offense X, you must register for 10 years, here, under this section, if it permits the court to determine any amount of time, does that contribute to the arbitrariness of it? For example, if he was ordered to register for 10 years here, similar to someone with a much greater conviction, does that undercut your lack of arbitrary enforcement?
I think it would, I don't know whether that would go directly towards whether it's unconstitutionally vague that the district court has the discretion to order enforcement, or to order registration. Perhaps it could go to whether, as applied in a particular case, the statute is unconstitutional. If the court had ordered this defendant, for instance, to register for 10 years or 20 years, or picked some crazy long number for this, but I think
You
that
think that'd
would
be more of an as-applied?
exactly, yeah. I think that would be much more an as-applied challenge as opposed to a fictional.
Can I ask you, in your vast experience as an appellate attorney, have you ever seen a statute been enacted before? I didn't even know it existed. Applied.
Applied? I don't
Thank you.
recall a case that I've worked on where it's been at issue. I think I was aware generally that there was a catch-all provision, but I don't think I remember working on a case or even necessarily coming across an opinion where it was an issue.
Thank you.
So,
Appreciate that.
yeah, I think, like I said, I just generally was aware that there was this provision that was out there, but I guess that would, to the extent that it comes up so seldom, would further indicate that this is not a statute that's being applied in a way that should concern us with constitutional requirements. If it's being limited to situations like this, where the court has specific reasons why it's concerned for public safety, and I think that would illustrate that this is not something that's being abused by district courts, that they are exercising their discretion in a reasonable professional manner. I see I'm past my time. we would just respectfully ask this court to, again, uphold the standard review and find that this statute is constitutional and that the defendant has not met his burden of showing otherwise.
Thank you.
Thank you.
Counsel? You have 3 minutes for rebuttal.
Thank you. I have been in contact with Mr. Cap's new attorney as he's facing revocation proceedings, both because of violations of conditions of probation and also, it looks like, because of violations of court. I believe he's got a hearing in December on this. Counsel brings up standing. I have filed a 609 letter about the Supreme Court's recent case in Stubbs, which, for the separation of powers argument or the arbitrary enforcement, says that standing is something that is available to people, generally speaking, who are affected by a statute. What it says, and that was a criminal case, but it says the Kansas court affected by a statute subject to vagueness challenges generally has standing to bring an arbitrary enforcement challenge against the statute. If the defendant is affected by the statute, that establishes injury, and the causal connection exists because that injury flows directly from the legislature's enactment of an allegedly void statute. So this argument is that the statute is void as it was drafted or enacted.
Do you have a cite for that?
Stubbs, yeah, it's,
Oh, Stubbs. I thought you said Dubs.
We've got stubs.
I've
We
got
have
Stubbs.
stubs.
okay, thank you.
Yeah, I just misunderstood you.
The same day that Stubbs came out, there was another case that came out. Should we take a further look at that?
I'm not familiar with the other case.
Okay, don't worry about that.
Sorry. The other thing that brought up is the length of time. I can tell this court that the judge relied on 224906I to subject the 18 months. Now that section is supposed to be for provisions of like agreements, I think, and for juveniles. So I'm not sure that it actually applies to this. But when I was looking at the statutes that for the different times, there is a statute that allows for 15 years. So I'd say this is an example of how arbitrary this is and how complicated it is to actually implement. And with that-
What about the argument from counsel that that would be more of an as applied as opposed to a facial?
Oh, this is a facial challenge.
No, I know, but if we were looking at the length of time as being a factor,
Well, when you're considering the arbitrariness of this, the question is if the statute is void. It's not a question of the facts of a case. So when Your Honor just suggested that, I wanted to clarify, first of all, what the district court was using and why I thought that might be complicating things a bit. It's not a factual matter. Actually, to me, it's more of a legal thing. That's what the judge relied on to impose the 18 months. With that, my time's out. Unless there are any questions, I'd like to rest on my briefs.
No.
Thank you very much.
Thank you for your arguments. All right, this court does appreciate the work and preparation put into this argument. We will take this matter under advisement.